Hello, everyone. Welcome to a new episode of Immigration Fridays. I'm your host, Prashanthi Reddy, and we're here again to navigate the ever evolving maze of U.S. immigration. This week, let's discuss USCIS Child's Acquisition of Citizenship Act. There's some new guidance on this matter. This is with reference to how a child can get citizenship if he's born to one U.S. citizen or to two US citizens, even if the child is outside the country. Now, there's been some update with reference to what the law is, and let's dive right into it. To start off with, the background is that the Immigration and Nationality Act provides that US citizens may transmit citizenship to their child born outside the United States in certain circumstances, as I just said. Children who are born outside the United States to a US citizen parent or parents may obtain US citizenship at birth. Children may also obtain US citizenship after birth, but before the age of 18, through their US citizen parents. So there's been updated guidance with reference to this, and this guidance is a result of a case that was decided in the favor of the immigrant. The name of the case is, it's a Supreme Court decision, Sessions versus Morales-Santana. So as a result of this court decision, some further adjustments were made and some things were changed. So let's first discuss a little bit about the case. With reference to this case, what had happened is a person was born outside the country to a US citizen father, but the mother was not a US citizen. Now, there is something within the law which kind of differentiates between a person born from a US citizen mother or if the person was born from a US citizen father. If they're both US citizens, there's no issue. But there is something called physical presence. And the parent has to show that they were physically present in the United States for at least 10 years before the child was born, and 5 of those 10 years have to be before they turn 18. So this physical presence requirement is different when it comes to mothers, unwed mothers. For unwed mothers, they can transmit citizenship to their child even if they were physically present in the US only for 1 year. But it's not so for the fathers. So in this case, unfortunately, it was the father who was transmitting the citizenship, and he fell short of the physical presence requirement by only a matter of few days. So the US Supreme Court decided that immigration laws can't differentiate based on the gender of the parent, and they decided in favor of the applicant. So as a result of this decision, some policy has changed, and it's become a little lenient, and also they've given some further explanation as to who qualifies, when the child qualifies, etc. So let's go through each point one by one, or at least the important points. So the new policy affirms that applicants who have already filed an application for a certificate of citizenship, and because if they were denied, because they were ineligible, and they become eligible based on changes in this policy, then they may file a motion to reopen, even if the case has been denied. Okay, so that's the first point. Secondly, the new policy clarifies that a US citizen parent may meet the requirements of physical presence in the United States before the child's birth, regardless of immigration status. So it doesn't, the parents do not have to be US citizens when they were physically present. Maybe they were out of status even, or they were permanent residents. So they don't have to be US citizens during their time when they had to meet the physical presence requirement. In addition to that, the policy clarifies that in cases where a child is born out of wedlock to two US citizen parents and cannot acquire citizenship from the father, the mother meets the requirement by demonstrating 1 year of continuous presence in the US. or one of its outlawing positions before the child's birth. So either the US or Puerto Rico, etc. So this is a clarification, and the clarification basically says that if they're both US citizen parents, um, and the father doesn't meet the physical presence requirement because it's more onerous for the father to meet it because it requires 10 years physical presence, the mother might meet that by demonstrating that she was in the US for 1 year continuously. So that's a change from the previous position. The next point. For purposes of acquiring citizenship at birth, USCIS requires that a parent must be recognized as a legal parent. So legally they have to be parents of the child. Next point. The policy further clarifies that a child acquires citizenship under statutes requiring all conditions to be met while the child is under 18 years of age. If the last condition was satisfied on the day that the child turns 18th or on his or her 18th birthday, then the person still qualifies, the child still qualifies. So even the day that they turn 18, they still qualify. So there's some leeway given, for cases where, maybe on that day they turn 18, and since they've turned 18, they may not qualify under the old law, but under the new law, they do. Next point the new policy confirms that USCIS accepts a valid and an unexpired US passport or a consular report of birth abroad or evidence of US citizenship. So, as proof of citizenship, these are the documents that they will accept. In addition, there are some other documents such as the new policy also clarifies that when USCIS, in addition to the applicant's claim of US citizenship, adjudication claims to US citizenship for applicant's parents or grandparents. So what they're talking about is, in this final point, is when it's not clear as to what the citizenship of the person, of the parent is, then it's necessary for the officer to first make a determination to confirm the US citizenship parentage of the parents, and then only they can give citizenship to the child. So they have to make further investigation to make sure that the parents are US citizens. If it's straightforward, there's no problem, but if it isn't, then they have to do further investigation into that. So those are few of the points with reference to new policy on children acquiring citizenship at birth when they're outside the country. Most of you may not even know that a child can automatically become a US citizen if their parents are US citizens, even if they're outside the country. And so now you know, and now you know that there are some updates to that policy as well. And with that, that's a wrap for Immigration Fridays. Hope to see you next week. Stay tuned. Thank you. Don't forget to subscribe to our videos if you like what you see. Also give us a thumbs up and share the video with your family and friends. Thank you.